All right, I get to do a happy dance, and I love it when I get to do a happy dance. It might just be something just for me, but I still do it. And I do it when I obtain old wills because I'm doing new wills for a client, but I know they have old wills out there in the world. And it's part of the process as far as trying to make sure they have their up-to-date plans in order. And we don't have any old original wills out there that can cause confusion later on. Because when we are in the world of wills and dealing with what happens when a person passes and there may be a probate, those old wills could get filed with surrogate's court, even inadvertently, or somebody may think that is the will, that is the current will, and try and probate that will. And there can be those kinds of complications. So my happy dance is because I know I'm making it easier for people into the future as far as clearing up confusion about old wills that are out there. And when I say out there, they could be in a person's possession, they could be with an attorney, they could be filed with surrogate's court, they could be with the nominated executor in the will, they could be with a friend, a neighbor, and so on. So I get an authorization for withdrawal of will signed by my clients. I notarize that document. And then with that document, I can take it to various places to ask, do you have an original will of this person? And if so, how can I get that original will from you? And it's always a bit of a process. Sometimes you're tracking down people, not sure if they have it. You're tracking down maybe a retired attorney. You're not sure about surrogate's court, things like that, but you get the answers as you move forward. And that's why I do the happy dance when I actually get my hands on those old originals. And it really just pleases me so much to know that I'm making things clearer for my clients and for the people that will be affected by their planning, because I know the grief that people can go through when these kinds of extra steps, if you want to call them, are not done. Now, talking about wills, I just had a meeting with a nominated executor, and I want to bring out some thoughts as far as estate planning and wills go. So first, we always want to have an up-to-date will in place. We never know what we may have upon our passing, if something comes in after death, and so on. But some cases, we really want to avoid probate if at all possible. And with the meeting I just had, I would have told the person preparing the will that although we will need an up-to-date will in place, having another way, another means to pass your major asset, which was real estate, is going to be so beneficial. And why do I say that? Well, one of the reasons is that there is something called a right to object against a will. So next of kin or distributees have a right to object against a will. The law is such that the law provides an opportunity for people who perhaps should know best if the person actually did prepare and execute this will according to the laws, if there was forgery, undue influence, if they knew what they were doing, if they knew the natural objects of their bounty, and so on. There's various requirements that one needs to have in order to prepare a will. And next of kin distributees are supposedly the people who would know if there were these other kinds of conditions which could cause somebody to object against the will. And as well, people may be adversely affected. And that is a term that means people who are named in prior wills but are adversely affected by a newer will, they can also object against the newer will. And that's part of the reason why I said get those old wills out or get them out from whoever may have them and destroy them or whatever is going to be done with them. But they can also cause problems in the sense that those people who are adversely affected then have this right to object against the newer will. And this could even be you have a nominated executor in a prior will that's now changed to a different person. That old nominated executor has a right to object against the will, and so on. Now, with the person that I just met with, she was married. Her spouse predeceased her. She had two children. They were half siblings. One has survived her and one predeceased her. And the one who predeceased her had various children. The various children step into the shoes of the son that predeceased her and can object against the will. Now, we have a lot of complications in regard to those children of the predeceased child, so her grandchildren. We could potentially be dealing with unknown. We have unknown children. We don't even know their names at this point. We also could be dealing with whereabouts unknown, and we could have some further complications because I think that the children were born from different marriages, potentially not marital children, and we could really have a whole slew of issues that we're dealing with. We may even need a guardian ad litem appointed by the court. That's a court-appointed attorney who's going to stand and act on behalf of the individuals who cannot be identified or cannot speak for themselves. And so as we were going through this person who I met with said, I don't understand. Well, why did she have a will? And then I went through the idea that the will has to go through this process called probate. And if that was not explained to her at the time she was preparing the will, as far as some of the complications and why there's some other route that is so much better for her, she wouldn't have known. And she would have thought this simple will is going to take care of everything. And so I think it's a real eye-opening experience. And I just want to get the word out more and more that, yes, we do need an up-to-date will. It's important to have no matter what. But there are especially certain considerations that make going through probate that much more difficult. And people need to be at least open to the idea of putting some major assets in trust so that those assets will avoid probate. Maybe other assets can have some other designations and so on, but a trust is an incredibly beneficial way to be efficient and helpful for those that you intend to benefit. I really could just go on and on about what I just went through in the meeting with this individual. I feel so much for people like this because I know that things could be so different. I know that the time and the fees that are going to be involved in moving forward with probate are going to be astronomical compared to what they could have been if she had set up a trust. And so just trying to get the word out a little bit more as far as the need to think about your specific situation and work with an estate planning attorney that can help you open your eyes to some of the things that you should be thinking about above and beyond just a simple will. So this is Ruth George with Ruth P. George Law, PLLC, Trust and Estate Attorney. This video, as with any video I do put out, is for educational purposes only. It does not establish an attorney-client relationship. And I look forward to seeing you on another video where I hope to get to use my, my paper here. I didn't use it this time around, but next time I'll try and get to it. All right, take care, everyone.